executive, and yet I could not interest, but those of us who were campaigning about it could not interest many MPs in it at all. They had been told by the Home Office that this was just updating the wiretapping stuff for a digital age and so on, and they had more or less accepted that. Now, the point I wanted to make, and just one simple example of that, because one of the things that we predicted and warned about when REPA was going through was that it would lead to mission creep on the part of the public authorities. And in due course, we found that local authorities were using REPA as a cover, as a justification for snooping on parents who were suspected of not living in the area where their children were going to go to school. Now, this is a clear example, or this is not rocket science, and yet it wasn't spotted. And so I suppose my concern is that I'm a great believer in the rule of law, but I would like to have intelligently crafted laws by legislators who cared about it and knew about it. And in the case of REPA, in my opinion, we didn't have that.
Okay. Michael,
I just want to touch on one aspect of REPA. We had a lot of talks about warrants, and specifically the two types of warrants, the REPA 8.1 warrant for domestic interception and the REPA 8.4 warrant for external communications. Now, one of the anomalies in this is that the difference in threshold between those two is quite considerable. And I wondered whether you would like to comment on whether, if we're looking at this law, whether that difference in threshold, where it's much looser, it's much lower level for the rebate for warrants, is still justifiable, or whether it should be altered in the other way.
It really relates to the previous question in a sense, because the distinction between 8.1 and 8.4 is that 8.1 is the targeted one against individual or organisation, premises, whatever. 8.4 is the one in which the minister also certificates a whole load of so-called selectors, which are then used in order to search the data which is collected. So in that sense, 8.4 are clearly much more general, and are the basis on which, are the basis for the bulk collection which we've just been talking about. Just one other thing you said there, I think, whereas the REPA Code of Practice does, and the Act, of course, refers to the fact that these only relate to external communications. But as we discovered from Charles Farr's statement to the Investigatory Powers Tribunal, which was then published, of course, the way in which this is interpreted means that these may be applied to many communications that people probably assumed were internal are actually assumed by that to be external. In other words, all their communications with Google, with Facebook, and so on are assumed to be external and therefore are subject to that process.
I think what I was really trying to get at was to ask you, given your analysis, what changes you thought should be made, if you do think changes should be made.
Well, can I just come back on that last point in answering that question? And even though the 8.4 warrants allow provision for a broader range of collection, they still have to apply the same principles of necessity and proportionality to that data that is collected that way, and you still have to make the distinction between content and events data. So I think it's covered legally by the overall structure of the process, and as I've said before, I can't see that there necessarily need to be any changes to it.
So, if I could just comment on that question, so it seems to me that the evidential standard should be raised for access to metadata or communications data. So there's the notion of directed surveillance, that category within REPA. And if you think about what kinds of data are included in metadata, it seems to me to meet the, as it were, the significance for the person being surveilled that normally requires directed surveillance authorization. So in particular, you get GPS data under metadata, and the level of detail of your life that's revealed by that is equivalent to having someone tail you around town for the day. And in order to tail someone, you require authorization at the level of directed surveillance. So it seems to me that access to metadata should also require the same level of authorization.
Hazel?
Just for clarification, it's similar to evidence that we've heard from lots of people, that they feel that the area where RIPA is out of date is the distinction between data and content, and that's now blurred because of the rich picture you can get from data, and that the distinction between internal communications and external communications is blurred now because if one end of your communications is abroad, there's a different regime, and again, so many of the servers and routers are abroad anyway. So those two areas have been put to us as areas where the current distinctions are artificial and outdated. Would that be broadly your view?
Thank you. Fiona McTaggart?
Talking about things which go overseas, one of the issues which we've had evidence about is concerned to the extent to which agencies might share collected information with agencies in overseas countries. And obviously, because of the international threat of terrorism, such sharing is inevitable. But what mechanisms do you think need to be in place to make that? What do you think we should recommend that should be subject to? I suppose is what I want you to answer.
This international sharing is a very important question because we are in a treaty with the United States, Australia, New Zealand, dating back 60 years. Its whole logic is information sharing based on signals intelligence, the sort of stuff we're talking about. So this has been happening for donkey's years. Since 9/11, it's been happening a great deal more. Now, while there will be operational rules, of course, by which agencies do share, the literature is clear that much of this sharing is entirely informal. It's not necessarily subject to formal agreements. In other words, most of this sharing remains beyond any existing form of oversight at all. As we discovered with the rendition controversy, if an individual country this committee tried to look at it, other countries tried to look at it, the Council of Europe tried to look at it, and of course everyone's blocked because no national agency will share with you information it's received from a foreign agency. So there is currently no mechanism for the oversight of intelligence sharing. In RIPA, there's one reference to information that our agencies may pass abroad. But there's no restriction at all on what we may receive, bar one, and that's the restriction on information which is believed to have been obtained by torture. Otherwise, there's no restrictions at all. There is no law, and there's no oversight of this whole area. So it is, for you, a considerable challenge. I would say it can only be done by committees such as yours, working with colleagues abroad, the biennial review conference that you do attend, I know, but to make more of those links to try and get a grasp on this whole area.
Thank you. Robin Butler?
Well, supplementary to that, I mean, isn't it the case that any information, any intelligence that our agencies get from overseas partners, our agencies are still constrained by the operation of our law, that it has to be necessary, legal and proportionate, and that if they're going for content, they have to have a warrant. Now, does that not help to satisfy you?
No, it doesn't. I think there are possibly two. There's a subtle distinction here. I think the law here, it would be clear that if our agency is receiving from a foreign agency some kind of raw data, then I can see how our own legal restrictions might well apply. But intelligence agencies don't really like sharing raw data with each other because it tends to betray sources and methods.
Yeah.
But what they will share will be a report. It will be a summary, a synopsis, or something like that. And that, of course, and that's, if you like, that's developed intelligence. That's not raw data. And I don't think there's to be any legal restriction in RIPA or anywhere else on their receipt of that.
Well, not on the receipt, but on the use of it. I think that there's because unless it's within the powers of our agencies, they can't use a report of that sort. Is my understanding,
but it could inform their future intelligent information gathering activities, though, couldn't it?
Well, can I just, while you've got the floor, Mr. Gill, you said earlier on, I just wanted to pick up this phrase, when we were talking about the public's acceptance of the activities of the authorities, you said provided a lot's acceptable provided they've got confidence. And then you just added at the end, which has been weakened by recent events.
Yeah.
Could you just elaborate on that? What did you have in mind?
Well, I think there's the whole area we're talking about. I mean, not the entire British public is consumed with the Snowden material, partly because, of course, it's only really been published in one or two bits of the press. But if you look at the poll data, such as it is in the last 15 months, and I realise one has to take poll data with a pinch of salt, but I think it's clear that there is a public concern about this form of intelligence gathering. My other comment, I think, was based on the fact that, I mean, you're an Intelligence Security Committee. This isn't the only bit of intelligence that you cover. And if we look at other issues, and I'm thinking particularly of the undercover policing controversies, and sorry, there's something else and it's gone. But if we look at that as well, then I think we see in the last 2 or 3 years there have been a series of controversies around the use of intelligence by the state, be it police or by intelligence agencies, which I think make people sense that something is not right.
Thank you. Could I, we only have a few, yes, please.
So may I just follow directly on that? I think that a fundamental difficulty is that because of the sensitivity of these matters, and because of the way in which the security authorities work, and because of the way this committee works, and so on, essentially the position often is that the public is being told that, for example, the threat's very serious. And if you say, well, actually, how serious is it? And the responses I couldn't possibly tell you, because we know, but you don't. So what it comes down to in the end is essentially a proposition, which is trust us. And in the last 2 or 3 years, we have seen a number of startling examples of where serious British public institutions have demonstrated vividly that they're not worthy of trust. We're talking about the Metropolitan Police, we're talking about Parliament itself in relation to expenses, and so on and so on. And in those circumstances, it's hardly surprising that there is a certain level of public scepticism about chaps in suits and ties telling you, don't worry, it's all right, it's terrible, but
what you say is, of course, correct, but it's got to be balanced by the fact that no one has yet produced a formula that enables the government to share with the British public this information without it becoming available to the bad guys in other parts of the world who are trying to do us harm. So, in a sense, I think the debate is not about trust us. It is about government only asking to be trusted in areas where it genuinely could not reveal information without doing damage to the very objectives that it's trying to protect.
I agree, Mr. Chairman, but trust has to be earned.
Sure, but that means that you only make the request to be trusted when it's absolutely necessary. And there have been occasions over the years when either governments or the intelligence agencies themselves have been more nervous about transparency than they needed to be. And the very fact the agencies have become much more transparent in recent years without any obvious harm to their interests demonstrates that perhaps they were overcautious in the past. Which brings me, in the last few minutes that we have, can I invite you, rather than for me to express a view, can I invite you to offer any views to the committee, both about the question of oversight and transparency, where you believe there are important arguments for change? Mr. Gill.
If I might, yes. I mean, I realise we haven't got much time, but on oversight, my feeling is that what has been exposed in the last 2 or 3 years is the rather haphazard, compartmentalised nature of the structure we have. Now, the ISC is at the centre of this, and in a parliamentary democracy, that's absolutely right. But the other parts of the structure, the commissioners and the tribunal, have developed on a rather piecemeal, haphazard way since 1985. And I think it is now clear that collectively they do not provide an adequate oversight structure. I would ask the committee to give serious thought to establishing an independent body, or suggesting the establishment of an independent body that will combine the 3 commissioners' offices together. The mandate for this office would be the oversight of covert investigation in this country. Because we're not just talking about communications interception, we're talking about undercover policing, and we're talking about various other forms of information gathering, as you well know. It is not appropriate now that interception communications is done over there, undercover policing is done over there for one institution, and undercover work's done by somebody else for the intelligence agencies. It's just a mess. So I would strongly suggest a single body. They could also receive the complaints and present a case to the tribunal, rather than the tribunal doing it all themselves, which I don't think is appropriate, not subject to due process. They'd receive complaints or concerns from employees, because we've had the staff counsellor for almost 30 years now, but very secretive. I don't really know, and no one really knows how that works. And I just think we need something that's joined up. We need joined up oversight, not the fractured system we have at the moment.
Thank you. Any other comments?
Could I just add one thing to that, Mr. Chairman, which is that for me and my colleagues, in academia at any rate, we would want to see oversight that is technically informed and competent in this area. We have oversight by lawyers and by judges and by parliamentarians and so on, most of whom are not up to speed on this technology. And I think one of the important requirements for credible oversight would be the inclusion in oversight processes of technical experts who are independent and who have security clearance.
Thank you. Other suggestions?
I would just briefly add that, I think the ISC has the potential to be an entirely appropriate and acceptable form of oversight. I think there is a case for perhaps some changes to it. I think the move from being an appointed committee of parliamentarians to being a sort of proper parliamentary committee is the right move. I quite like the idea of bringing in some technical experts to the process. I think there's a lot of merit in that. But the basic principle, it goes partly back to an example is the sort of example we had just a short while ago of international relationships with our intelligence agencies. I presume and I hope that the ISC could scrutinise those relationships if it wanted to, and look at and see what's going on, what data is being shared with overseas partners, and is that appropriate? If those provisions are in place and the ISC has sufficient powers, then that for me is a perfectly acceptable level of oversight.
Professor Simpson? No, thank you very much. Just to point of information as a final comment, the recommendation about the ISC having more access to technical information, we actually can use and have used technical advisors when we've thought it to be appropriate in particular inquiries, but there may be a case for expanding upon that in the way that you're suggesting. Can I, on behalf of the committee, thank the panel for their very, very helpful contributions. We've had both the benefit of your written submissions and the oral evidence today, and it has given real added value to our deliberations. Thank you very much indeed.
Thank you.
Order, order.